is the video on government policy, so land, security, and freedom, the second part of this topic. So to continue with our In the News segment of the class, in Blackboard, please post your news articles with short comments in the discussion area. After the class, you can also post any questions or comments in Blackboard, even just to say you were online, and this is just to help me with record keeping. And if you are not able to be online for the virtual class for any reason, please post any thoughts, comments, questions here. And it just gives me a record of who's been thinking about the topics and is able to be involved. Due to everything that's going on, I haven't had the time or the energy to do any marking. I think I got halfway through one essay. It will get done, but it is going to be much slower than usual. I think we're all feeling a bit discombobulated, and as best, in spite of our best efforts, things are moving a little more slowly, I think, just with all the juggling that has to go on now. So just be patient, things will get done, and if you need any extensions or help getting through things, just let me know, please. The first chapter that we were going to talk about this week was by Gunn, called Getting It Right, the Canadian Constitution and International Indigenous Rights. I usually start with what is the main argument, and what Gunn is arguing is that the potential of Section 35, Part 1 of the Constitution Act is limited by the interpretations that have been given to it by the Supreme Court of Canada. So Gunn is arguing that UNDRIP provides a framework for which the Canadian courts can turn to in order to realize the potential of that section of the Constitution Act. It's similar in some ways to the chapters from last week where they were thinking about the role of UNDRIP in Canada's context. It's important to note that in Canada, the debate over the UNDRIP ranges from perspectives that say that UNDRIP has no legal relevance to it being an aspirational goal to try to achieve, to it saying that it reflects customary international law and that it should then be directly applicable and binding in Canada. Gunn argues that at a minimum, the standards set out by UNDRIP can provide a framework to reinterpret Aboriginal and treaty rights under Section 35, Part 1. And this argument, Gunn says, provides a middle ground to the all-or-nothing debate. So there's a presumption of conformity, which requires Canadian law to be interpreted in conformity with international law. And this presumption of conformity is important, I think, here. Early relations between Britain and the Indigenous peoples were nation to nation, as we've discussed before, but that relationship has significantly deteriorated since the relations first began, and that's quite obvious, of course. The inclusion of Section 35(1) allows courts to decide what rights were existing, and the section was something that was debated. So it was put in, it was withdrawn, and then it was reinstated. And at the time it was first put in, the Indigenous people were cautiously optimistic, as Gunn says. Now, international law more explicitly recognizes that Aboriginal and treaty rights stem from and are grounded in the Aboriginal people's own legal systems. And so this grounding is connected to the inherent rights of Indigenous peoples and is not supposed to be contingent upon recognition from any state or court. Now, Canada's statement of endorsement of UNDRIP reflects the political position that it doesn't have legal effect in Canada, but is instead simply aspirational. So this presumption of conformity requires that Canadian law be interpreted in a way that's consistent with Canada's international obligations. Now, Gunn also raises the question of what tension is there between using litigation and moving towards negotiation. And he says that moving from litigation to negotiation moves the issues from the legal arena to the political arena. So it changes the nature of these debates. In terms of evidence, Gunn goes through a few cases that represent or provide examples, I guess, of what he's talking about. So the Sparrow case led courts to, quote, require a valid legislative objective to justify interference with Aboriginal rights, end quote. So this gave a justifiable infringement test. So if we look at Section 35, Part 1, it protects Indigenous peoples from federal government interference. So justifications for interference is actually much broader in Section 35, Part 1 than is indicated or suggested in international law. Gunn says that under UNDRIP, restrictions should not occur through unilateral government action. Under Canadian jurisprudence, interference is only justified after minimal consultation, and UNDRIP would say that it should be much more robust than that. Gunn also mentions the R versus Vanderpreet, the Regina versus Vanderpreet case, which was about the right to sell fish, which was vigorously contested by the Crown. And so the approach taken by Larmer does not follow the Sparrow principles. He says that there's an inherent contradiction. How does the Crown gain the right to adjudicate if Indigenous people's right to the land was pre-existing? And so the effect of this particular case is to, quote, freeze Aboriginal peoples as historical anomalies and to prevent them from expressing themselves through contemporary cultures and practices. So it limits economic rights, and there's a loss of remedial scope. They comment about the fact that dissenting opinions are important. So even if these dissenting opinions don't represent current law, but they can provide, they can be used as, quote, persuasive authority when trying to point out flaws in the current system of laws. And they say to fulfill the goal of reconciliation, the interpretation of Section 35, Part 1 rights must not blindly rely on colonial legal principles, which would just therefore perpetuate colonial injustices. So Gunn concludes a few things here that renewing the interpretation of Section 35, Part 1 based on UNDRIP allows for real recognition of the source of protected rights as Aboriginal people's own customs, laws, and traditions. And he says that part of a renewed interpretation of Section 35, Part 1 must allow Aboriginal people's cultures to continue evolving. So Aboriginal peoples cannot be just seen as historical anomalies. Their culture needs to be allowed to evolve as every culture does. So the approaches, he also concludes that approaches based on racist notions of Aboriginality as historic cultures, like those found in museums, must be rejected because of their racism. The second article, which is by Joffe, argues that the Canadian government has repeatedly cast aside its constitutional and international obligations. Joffe goes through some of the actions that the Harper government has done or not done, saying that since the federal election in 2006, the Harper government has refused to even discuss the nature and scope of its obligation to Indigenous peoples. So the main argument here, too, is that Indigenous peoples' collective rights constitutes human rights, which I believe one of our other readings also said. By adversely affecting these human rights, the federal government is undermining the security of Indigenous peoples and Joffe argues that security and human rights are interrelated and they entail international responsibilities. And so this chapter also goes through some of the details about UNDRIP and how it can be applied and the importance of it as an international human rights instrument. This chapter also points out that although the UNDRIP was adopted in 2007 by Canada and that Canada endorsed it in 2010, in that lead up to 2010, Canada opposed the adoption and implementation of the UNDRIP at home and abroad. And when they did so, Joffe says, Canada aligned itself with states with poor human rights records and histories of repressing Indigenous peoples and individuals. And they argue, Joffe argues that even after Canada endorsed UNDRIP, Canada ignored its significance and legal effects. In terms of evidence, Joffe provides an overview of the various actions or inactions of the Harper government over the 8 years or so of its terms. And he makes a few points about the fact that the Canadian government is applying a different and lesser standard of democracy, human rights, security, and the rule of law when it addresses the rights of Indigenous people. So that because the government is refusing to acknowledge that Indigenous people's collective rights are human rights, they're really just treating Indigenous peoples differently than any other people. They make the point that Canada's ongoing failure to address Indigenous people's collective rights as human rights is, in fact, racial discrimination. And it goes through, this chapter goes through a number of examples from different places in the history of Indigenous peoples in Canada. I'll highlight, I clicked a little too fast there. I'll highlight this point about the doctrine of discovery and terra nullius, which we've discussed before, and the importance of the fact that the government has underfunded essential services and have harmed Indigenous children. And I think this is an particularly important point given the pandemic that we're experiencing right now. I'll post a few things on the next slide about this question. Joffe concludes that Canada's record on dealing with Indigenous rights is quite clearly appalling. The governments of Canada at all levels have deliberately done things to undermine UNDRIP. And these are things that have violated core Canadian and international principles of justice, equality, and non-discrimination, as well as respect for human rights. So it's really the opposite. Their actions are the opposite of good government and constitutes an abuse of power. So just in terms of thinking about some of the last thoughts, I've got on the screen a link to Indigenous news on the CBC website. In terms of what progress have been made, if anything, regarding Indigenous rights, land rights, children's rights, I do note that there is this one result that just has come in. It's sort of got lost because of the pandemic news, but the tribunal ordered Canada to compensate parents who lost children while in care. And so the link is there on that screen. And then I found a bunch of different stories about how Indigenous communities are dealing with the pandemic. And I apologize if this duplicates anything that people are posting in the news articles. But, you know, there's different communities are dealing with things in different ways. So the first article I've got listed here is saying about the fact that the Ontario First Nations are moving resources from one area, and they're not going to have those resources left after the COVID-19 emergency ends, and they comment that pandemic plans are outdated. And I would suggest that this is probably true also in terms of the general community. I think we've become a bit complacent so that our pandemic plans have not been updated to account for things like the increased number of homelessness and the opioid epidemic and so on. The second article indicates that Saskatchewan First Nations need at least $20 million to fight the COVID-19, says one chief, and noting that the need is the greatest in northern and remote communities. I did find this one article, the third article here, that one First Nation chief was planning for this pandemic weeks before it hit, and he actually ordered resources in a couple weeks early. So in the article it says that if a 2-week quarantine is necessary, people shouldn't have to leave the reserve at all. He got enough. He ordered it a week and a half or so before the government started warning about people needing to go into isolation and things like that. So he was able to get those resources in. So I'll look forward to seeing you in class and your postings online. This ends the video for this week. There's only one video. Thank you.